utterly ridiculous, didn't happen, on how ridiculous. I find that ridiculous, but that's what happened. In my view, we can win this point. Some people wondering why your insurance premiums are so high. That's possibly one of the reasons. This is a horrendous story that reflects several that I've seen in real practice. This person was hit with an $18,000 court judgment for something they weren't even involved in. So I'm going to go through this story and what you might be able to do if you're involved in something like this and how you might be able to prevent it in the first place. So this story comes from Reddit, but as I say, reflects many in real life. This person, albeit in the United States, many of the principles will apply in the United Kingdom or whatever jurisdiction you are in. And if I could ask you for one small favor on a serious problem that I have, please hit that subscribe button, because about 70% of you don't, out of the millions of you that watch every month. And I'd be really grateful if you did, because that's my one big metric to know that I'm reaching a wider audience. Thanks for doing that. Back to the video. This person said, so apparently someone has used my name after being in an accident and hit a parked car. I've got a funny story about a parked car, which I'll come back to in a moment. Again, real case that I actually went to court for, absolutely outrageously ridiculous, but I'll come back to that in a minute. This person continues, the owner of the parked car sued me, for which I knew nothing about. The judgment was issued and now I'm in debt for $18,000 for what it seems to have been a fender bender, just a minor collision. Not only am I in debt, but my privilege to obtain the driver's license has now been revoked. I'm a single mother and have absolutely no way of paying an $18,000 or a lawyer. Anyone have any advice on what I could do to at least get my license back? Now, because I'm not in the United States, I can't really give even any guidance on how to get the license back, save that the broad application of what you might do might lead to you to be able to get your license back. And for anyone else watching, this is not legal advice, it is broadly guidance. So what's happened here is someone has obviously used details that were not their own and given false details. This is not something new, and in doing so have escaped judgment because they've sued the wrong person, which is an important factor on what you might do about it. Obviously that is fraud, because by giving false details it is a false representation with a view to make either a gain to yourself or a loss to somebody else, and whatever jurisdiction you're in, that is going to amount to fraud. But that aside, which you could report to the police for, you could report it to the police as a fraud, and the police might be able to assist in that regard. But as far as the courts go, again, I'm not a US attorney, but the principles will be broadly the same, and certainly in the United Kingdom, in England and Wales, where I practice as a barrister, what we would do is as follows. If you get notice of a judgment and you've never heard of this case before, you've no idea what's going on before, but you receive this judgment, you must act as quickly as possible. That is one of the major factors in getting this resolved. You must act as quickly as possible. And like many things with law, the most simple explanation is usually the correct one. And the most simple and the correct thing to do here is you have to go to the court to tell the court that you knew nothing about this judgment. In England and Wales, under our civil procedure rules, we call that an application to set aside judgment. It's probably, in a case like this, it will probably be default judgment because they wouldn't have received the documents. If they had received the documents, that's an entirely other matter. If you've received the documents beforehand and ignored them because you thought that it was nothing to do with you, you might then struggle to get it set aside. However, this sounds like a case where they didn't receive the documents, and like many cases, like actually a couple of stories I'll come back to, where they didn't receive documents, you might then have another reason to set it aside. More about that in a minute, I'll explain that. But in the case where you've not received these documents before, you've never seen them before, you would need to make an application to set aside judgment. Now, when you make an application to court, when I'm teaching trainee barristers, what I say is you are asking the court to make a decision. In fact, anytime you go to court, you're asking the court to make a decision. The court includes the jury, by the way. And so if you're prosecuting somebody, you're asking the jury to decide guilty or not guilty. And that is a decision. In the case of making an application to the court, you're asking the court to make a decision to set aside the judgment. That means the judgment essentially, not that it doesn't exist because it's been previously made, it's just that it is no longer in force. So a judgment is active and enforceable unless and until it is set aside. And a court has the power to set aside that judgment in a number of different situations. One of which being here, whereby you've never heard of this judgment before, you've never heard of the details before, it is not you, your identity's been stolen, and obviously the vehicle involved is, in this case, almost certainly not going to belong to the actual person whose details has been used, and then you will give the court the full information as to why this judgment should be set aside. Now, in doing so, in making such a decision, the court will have regard to how quickly you acted once you received this judgment. So as part of your application and a witness statement in support, so an application will have evidence, not always, but will usually, and certainly as best practice, would have evidence in support of that application. Evidence can be in the form of a witness statement or any other kind of evidence, which ideally would be appended or annexed to your witness statement. So your witness statement will set out, I received this judgment, I've no knowledge about it, this is not my car, I wasn't there, etc., etc. Someone's clearly used your details. And if you do have a vehicle, which is not the vehicle in question, you can append details of that to your witness statement to show this is my actual vehicle, it's nothing to do with this one. And so you'll append all of those, you'll file that application with the court, you'll wait for your court date to have a hearing on this. Ideally, you should contact the claimant in the case if you are the wrong defendant, and you should say, this was nothing to do with me, this is the first I've heard of it, they've obviously stolen my details, would you consent to this judgment being set aside? The reason you do that is because if you make it clear, particularly if there's a lawyer involved, they should be quite reasonable and amenable to an application to set aside the judgment and consent to that without going to court. The reason for that is parties are always under a duty to cooperate in order to reduce the time and the costs burden on the court. That is what we call the overriding objective. So you should contact the claimant in the first instance or their lawyer and say, this was nothing to do with me, would you consent to the judgment being set aside so that we can get to the bottom of it and who was really responsible, and perhaps even attempt to substitute the correct defendant if for some reason you know who that might be. But if not, you make it clear that it is not you, your identity has been stolen, it's nothing to do with you, and you plan to apply to set it aside. If they refuse, as in if the claimant or their lawyer refuse to agree to set it aside, then you go ahead and you make your application to the court. But you do all of that promptly, and the court will have regard to whether or not you did that promptly. And when you get to court, the court will then make the decision whether or not to set aside judgment. And in doing so, you will also ask the court to stay or pause enforcement so they can no longer come after you for the remaining debt. Once you get a judgment like that set aside, if it's had an effect on your credit rating, for example, you can take that back to your credit reference agencies because it's probably ruined your credit report by now if it's been more than 28 days and been reported on your credit report. You go to your credit reference agencies and say, here, this judgment has been set aside, so please remove this and expunge this from my credit report. If, in the case of this person on Reddit, has lost the privilege to obtain the driver's license, I would go back to what do they call it? The DMV, the licensing agency, whatever they call it. Go back to them with a notice that the judgment has been set aside, or whatever the equivalent is in the United States. And certainly here, not that this applies with the DVLA to have a license revoked for the same reason, but if it did, for example, or if there was any other ongoing impact from a judgment, you take the order setting aside judgment to whomever has had an impact on your life and so on, and they should nullify whatever that impact is. But in the terms of credit reports, take it to your credit reference agencies, provide it to them and say, this is wrong because the judgment's now been set aside. And unless and until it's reinstated as a formal judgment, it shouldn't appear on your credit report. And they should cooperate with that. And so another example of when this happens is when a claimant, in my experience, some claimants, in my view at the very least, have deliberately used a very slightly incorrect postcode so that later on they can just say it was a mistake. But the reality is the papers, the claim form and everything else doesn't actually arrive with the defendant. So one digit wrong in the postcode, you might get a good sorting office actually redirect it to the correct address, which I've seen happen before as well, which I've thought to myself is an attempt by the claimant, in my view, to subvert the real good service of the documents. Not that that is a good strategy long term, because it will all get unwound and potentially the costs land with the claimant anyway. However, some, in my view, have done exactly that. They've used a very slightly incorrect postcode so the documents don't land with the defendant, so they can then go ahead and get default judgment. Judgment in default is a default of response to the claim form or default in filing a defense. Because very broadly speaking, you get 14 days within which to respond to the claim form, either by an acknowledgement of service or by filing a defense. If you file the acknowledgement of service, you get a further 14 days within which to file the defense. But if you do neither of those, they get judgment in default. They get a judgment without a hearing, without anyone turning up, without any argument, without anything at all. They just get it by filing your request, not even an application, by filing your request with the court for judgment. And then if they've got all of that because you didn't get the papers, because you've never seen the papers, and then what I've seen previously in real practice, miraculously, is the judgment does arrive with the defendant, with the incorrect postcode intact. So it's a bizarre set of circumstances. Either the defendant's not been honest with the lawyer and they've actually have received the papers, but they've ignored it because of the incorrect postcode, which again is not a good strategy. Be honest with your lawyers. Or in the case where they are adamant that they didn't receive the papers and the judgment is the first thing they've ever received, then you're back to court, and more often than not, the court is going to set aside judgment on the basis that the address was wrong, service was ineffective, and the court must set aside judgment. So those are all scenarios where you might end up with judgment without having anything to do with the case at all. And you'll know this video is not in any way sponsored, but you know that I support both Incogni and NordVPN because they help to protect your identity online. I will leave my links to those in the description below, but this is not a sponsored video. Now, as I promised, one final story whereby I found it utterly ridiculous. It was, funnily enough, to do with a very similar case like this. It was a parked vehicle that had been hit in a car park, and one vehicle reversed into the other, and the claimant in the parked vehicle claimed that not only his coat, but also his sweater underneath were torn in the collision of this vehicle reversing into a parking space next to him and caused about 6 inches worth of paint damage on the front bumper of his vehicle. I was ready to argue this in court and say there is no way that this minor collision, which caused a minor scratch on the bumper, could possibly have torn the jacket and the sweater underneath. You know, what did it tear on? The steering wheel as he was lunged forward from the... It was just an entirely ridiculous scenario that I was fully prepared to cross-examine in court, only to get a note from the solicitors and the insurers that the insurers had settled that part of the claim for about £300 and something for both items of clothing. Moments before we were about to start the trial in court, and I was ready to cross-examine this claimant. For reasons I cannot explain, that part of the claim was settled moments before going into court. I find that ridiculous, but that's what happened, and I act on instructions. I did sort of push back and say, in my view, we can win this point, and they said, no, we've settled it. We've agreed to pay it. So some people wondering why your insurance premiums are so high. That's possibly one of the reasons, because some of these claims just get waved through and paid without so much as a challenge. Bearing in mind, they'd already paid me to attend court. I was sitting in court waiting to cross-examine this claimant on how ridiculous, and that there was no way that the judge was going to accept, which in my view they wouldn't have accepted. There was no way this judge was going to accept that the clothing was torn by this minor collision at sort of 2 miles an hour reversing into this car parking space. Utterly ridiculous, didn't happen. Was certainly not a result of that collision. But that's what happened, and that's my story for this video. So if you found that anyway useful and entertaining, please do like the video and subscribe. And as always, thank you for watching.